Welcome everyone to today's session where we're looking at the topic of dealing with trustee changes. We know that this is an area of real importance within our SMSF client base, not only where we see structural changes from, say, individual trustees to a corporate trustee, but we are more and more seeing changes being required within the trustee structure of the fund because of much older client base, where we might see the appointment under enduring powers of attorney due to incapacity, and we may also see it in respect to the death of a member. In a much bigger, society, we are also seeing more and more people move overseas and therefore requiring other types of legal representation to support them as well. And so today is all about helping you to understand some of those processes and then looking at the documents that we currently have available and those that we're working on to be able to support what you do and see in this area of changing trustees. Now, as is the case with any of these sessions, we're going to be giving you both some technical aspects to these things, but then also give you some practical application and take you to the site and help you work through what we actually have on the Smarter SMSF platform to overcome these things. So in terms of what we're going to be talking about, we're going to be looking at identifying what some of these different changes are that could occur. We'll then undertake some sort of assessment as to what those steps might look like in that process. We'll look at the documents as we sort of work through these areas. Most importantly, and one of the additions that we've had this year, of course, is our Smarter Legal Review that you can then incorporate if you want to make sure that some of these changes have been done and done correctly, that would allow for that legal sign-off and that, safety blanket, in essence, that allows you to ensure that that has been done correctly with the appropriate legal support behind it. And will then give you some idea about, broadly what we have in our existing suite of documents and what we're continuing to work on as well. So when we think about these changes to trustees and trying to understand in what ways do we see these changes in trustee structure, well, there are a broad range of things. So as I said, succession considerations is probably the most important and most common one that we see when we are talking to our members, and I'm sure when you're talking to your clients, and in particular that focus of why a corporate trustee would be better suited than individual trustees. And in many instances, we continue to see with that ongoing conversation that is occurring, the fact that people are then looking to make that change whilst clients are cognitively able to do so and be able to make the changes to the assets. And therefore, we're seeing that change of trustee to allow individuals move into a corporate structure. We've also seen, through the inclusion of an additional 2 members since July 2021, the fact that we're seeing more parties being involved in self-managed super funds, the fact that we see intergenerational members, so where we've got not only mum and dad, but maybe then kids inside that fund. And again, it's needing to have changes made within the definition of Section 17A to see whether they're appointed as individual trustees or they become directors of the existing corporate trustee. And these other 3 items here are really, again, highlighting what I spoke about at the very beginning, that we're seeing more older clients in our SMSF client base that are losing capacity. So we know the impact of dementia having in much older Australians. We know that death is one of the only certain things in life. So we're going to have to deal with those issues with our clients as well. And the fact that we need to understand our residency rules and where we have clients that are moving overseas for maybe jobs and so forth, and looking at the issues between temporary and permanent residency, and therefore, again, understanding the nuances around the trustee structure as well. Now, when we identify any of these situations with our clients, we then need to understand the various reporting considerations that sit around these things. So we know with a corporate trustee, we have obligations with ASIC, and we must report whatever that event is that occurring within the prescribed 28-day time frame. Now, when it comes to the ATO and we're seeing changes in that trustee structure, then again, we have to report those change of details within 28 days to the regulator. And that not only incorporates the trustee here, but in some instances, we might need to be picking up member information as part of that as well. But when we make a change, we then also have to contemplate issues that may relate to financial institutions, so where monies are being held or assets are being held, the registries as well. So if we are moving from individual trustees to a corporate trustee, we would need to show and change the ownership of those assets to ensure we're complying with SysReg 4.09A. And then finally, there may be some other considerations. In particular, when we're thinking about property, there would need to be a change, in particular where we have individual trustees, again, to show that change in the titles office to move from John and Jane Citizen, for example, across to Citizen Family Super Proprietary Limited as trustee for that Citizen Family Super Fund. Now, they're the practical elements that we would need to walk through and the regulatory requirements that sit behind those. But what we also need to wrap our head around as part of that is well, what does our superannuation law tell us we need to do? So how do we ensure that we continue to comply with the requirements of Section 17A, so our SIS definition? And then what do our book of rules say, both in the context of our self-managed fund and where we have a corporate trustee, the requirements under the company constitution as well. So we need to sort of bring in all of that together when we go through and we look at any of these changes that we might see in respect to the trustee structure. So as part of this, if we kind of start at the beginning in terms of what we see as the most common approach, so where we move from individual trustees into a corporate trustee, one of the most important things that we need to do to ensure that we have a valid change, right? And a valid change means that we need to ensure that we understand who have the powers to actually undertake and approve this specific decision. And we have seen over time a number of cases where the fact that the transfer from maybe individual trustees to a corporate trustee hasn't been done correctly, and either that has been challenged in its own right because of the fact that the procedure in respect to that approach wasn't done appropriately, or we needed to go to the court and then actually seek that court approval as to which trustee was correctly put in place based upon the documentation that had been done, and had it been done correctly, or could they find it, or whatever the case may be. Now, a common thing that we see quite often here is when we look at who has the powers, is to actually go, who are the parties that need to approve such a decision? Because yes, it would naturally be the trustees, but it may also incorporate the members and others that may be linked to that deed. Okay, so we commonly see founders, employer sponsors or participating employers. These sorts of things are crucial to have those also approved to ensure that, again, we have a valid change that is occurring where that corporate trustee is getting appointed and those relevant parties are getting retired. Now, then once we understand who has the power to approve, we then need to know, well, what are the steps to ensure that that approval is done and is done validly? So does it need to be done by way of deed, or can it simply be done by some sort of minute or resolution that is ultimately agreed to by those that have the power to make a decision? Now, within the Smarter SMSF deed, you can see here our Rule 2.4. So what it makes very clear here is that the trustee or members of the fund may, by deed, okay, appoint a new trustee, provided that the fund remains a complying SMSF, and then it goes through sort of the rest of it that you can see there. But it tells us quite clearly who has the power and how those who have the power can authorize fact that it must be a complying SMSF, remains a complying SMSF. Now, that's a defined term in the Smarter SMSF deed, which means that we need to comply with the requirements set out within Section 17A. The other thing here is that it requires consent. So the new trustee or the replacement trustee or the additional trustee must consent to their appointment. So therefore, we would have the consent to act included as part of this approach as well. We must ensure that the new trustee or director is not disqualified. That is a crucial part to the definition contained within Section 17A, and that they agree to abide by the rules of the fund and the various superannuation laws. Now, the super laws there is defined within the deed to include a whole range of laws, not just the SIS Act and SIS regulations, but we have disclosure in respect to the fact that they're not disqualified, and then we have a level of acknowledgement that sits there as well. Okay, and as part of that process, you can then see in Rule 2.5, a trustee that is to be removed would require them to either retire or resign. So we're looking at then the approach that the deed defines as to how that documentation will be put in play to, again, ensure that we have a valid process there around the completion of the change to a corporate trustee. So when we then look at it in the context of the Constitution, so again, how are decisions being made within the Constitution of the fund? So does it match the SMSF? This is one thing I'm very particular on when we see clients that are doing deed upgrades over periods of time, because we might see funds that are in their second, third, fourth iteration of an operative deed within the fund, but the original governing rules in respect to the Constitution, that corporate trustee, are pretty much aligned to the establishing deed. And in a lot of instances, there is no alignment in that decision-making between now the operative deed in the fund that may have been updated in 2024 to the Constitution that may be back in 1998, it may be in 2004, it may be in 2012. Whatever that case may be. And the reason why that becomes crucial is all around decision-making, okay, and how directors will vote. And you can see that on the right-hand side where we look at Rule 10 and specifically 10.6, which in the Smarter SMSF deed, we do this on a proportional voting basis. Now, in Rule 24, again, where we look at decision-making and so forth, that decision-making again, is ultimately done in a proportional way. And therefore, if we have a different mechanism that sits with our Constitution, which may be just simply one person, one vote, then you're going to have very different outcomes under a corporate trustee versus that individual trustee approach. So again, just understand when you're going through these changes and upgrades that you may be wanting to ensure that you're upgrading not only the deed, but also looking at that Constitution that may be in place. And therefore, when you're making changes within the trusteeship of the fund, you may be also considering the outcomes that you're trying to achieve throughout that documentation in place. So when we look at changes ultimately under a Constitution, there are some really important steps, because if we're bringing someone in to this company, then we need to ensure first and foremost that they have a director ID in place and that they have obtained that director ID at least 1 day prior to any appointment. So that is set out within the Corporations Act, that 1 day prior. So again, just a little tip there to make sure you're ticking the box strictly in accordance with what the Corporations Act says. Again, it goes back to the consent that we spoke about before. So the consent to act as a director. We see that special purpose company incorporation in this respect, where we're going to be bringing on a corporate trustee for the SMSF. We would then see the ATO trustee declaration being completed if that hasn't already been completed historically in respect to one or more of those members. And then we would have our relevant reporting requirements, both in the context of our ASIC requirements, so our change of company details form, where that would be relevant, and then our ATO reporting, which we do our change of details for super entities, so a NAT 3036 form. and making sure, again, we're meeting the prescribed timeframes around any changes that may be occurring in that regard. And then the final bit there is again, just making sure we are very clear on how those documents can be executed. So within the context of the Smarter SMSF deed here, we now do have a Rule 30 that allows for decisions from meetings and the like to be done in a technology neutral way. So therefore, they could be executed either in electronic form or they could be executed via wet ink. And equally, in terms of the Constitution, we now do have the Corporations Act specifically excluded from the Electronic Transactions Act requirements, which in essence means that those documents that need to be signed electronically can be signed electronically under the Corporations Act. So there's no exclusions to the exemption that applies under the Electronic Transactions Act there, which still does apply to SMSF, but for some very specific circumstances, including the signing of financial statements. So again, there's some nuances there just around electronic execution that you would need to be aware of, but under the Smarter SMSF deed and Constitution, you would have no problems doing those in either form. And again, we do have our change of trustee document there. It is one of our most common, where you can simply undertake that deed of appointment or retirement. And I might jump over there quickly and just sort of explain the different aspects to that particular order form. So I'm in here in our Smarter SMSF platform here, our older platform, obviously our new version that we're rolling documents into at the moment. But what we have in here, once this loads, under our change of trustee form. So if I just go down to the change of trustee that we can see here, what this form allows you to do is to deal with all of the various combinations in respect to the change that is to occur. And what I mean by that is not only are we looking at the type of change we're making, so are we going from individuals to company, which we've been obviously talking about, and it's the most common. We may be going the other way, so company to individual. We may be just simply adding or removing, or adding and removing individuals. So we may be, in this instance, John and Jane Citizen. Jane is being removed out of that process, and Jessica is being added into that process. And therefore, we can go through and deal with that, I guess, combination. So we have a deed of appointment and removal, a deed of appointment and removal for our company there. We have a deed of appointment for our add individuals. We have a deed of removal for the removal of the individuals. And the last two here are also both a deed of removal and appointment as well. Now, the other part to this, of course, is, well, who are the parties that need to approve this change to occur? So again, it's going back to what I said on the previous slide here before. Is it the trustees? Is it the members? Is it both? Is it the trustee with an additional party? And if there is an additional party, then we're required to actually go through and incorporate who that additional party may be. So is it a founder? Is it an employer sponsor? Is it a principal? Understanding who that particular change is, and that whether that change is actually an individual or it's a entity, and therefore the representatives under that particular entity as well. So there is some complexity in that process of making sure that we get who's who in the zoo right, to ensure that that change is actually valid and done correctly. So coming back to the slides here again, what we now have here is, what we look at I guess we have a corporate trustee in place, is where we have this cessation of a director and that member. We have the understanding of how do we need to actually deal with this, both in the context of our funds governing rules, but then also in respect to the Constitution itself. So similarly, as I spoke about before, we need to go down to the rules and understand explicitly how this event occurs. So is it by deed, is it by resolution, or is it otherwise? Now, one of the common things that we see when members are leaving, departing, and this could be as part of a rollout process, it could be in respect to some other form of departure under family law, it could be also in respect to potentially the death of a member or even incapacity. What we do within the Smarter SMSF constitution is and again, this is where the importance of linking these two documents together. Because when a member leaves a fund and they may have left and you've resigned them as a director, have you actually dealt with the shares that that individual held as well? So if we think about a marital breakdown and we go through and there's a process that requires us to remove those particular parties, and you do that, unless we see some sort of specific requirement, maybe under the family law court orders, then potentially it's one area that we see get skipped every so often because we don't really give a lot of attention to that particular process around the shareholding because, again, it doesn't fit within the 7NA definition. One of the things that we do very explicitly within Rule 13.6 of the Constitution is that once the member has left as a member of the fund under the deed, then there is a forfeiture of those shares. So ultimately, there's going to be no loose ends held because if they were then going to try and influence any decision-making through their shareholding, they would not be able to do so simply because of that provision here, where effectively they have forfeited their shares as part of them ceasing to be a fund member. So again, we're going back to here, we need to deal with the membership rules in this instance. So we're going to our deed. What does it require us to do around ceasing to be a member? What do we need to do both in respect to what the governing rules say, but ensuring that we're complying with those relevant requirements that sit within the Income Tax Act and the SIS requirements, super stream rollovers, for example, lump sum payments out, withholding obligations, et cetera, and again, we move back to the fact that we have our reporting requirements to the ATO's regulator within 28 days as well. And then again, our shareholders. So how do we deal with our director and shareholder requirements? We go back to our constitution. We look at the relevant rules in respect to the director and that specific forfeiture of shares in this instance. And again, we do that relevant reporting. So we can see here with the removal of a director, we've got a range of these available on our site as sample documents. So very simple, but in essence, what we're doing is we're saying we see formal notice of resignation here. We then have the decisions that need to occur in respect to that particular member / director resigning from that role, the reference to the rule and constitution, and then the necessary tasks that need to be done administratively, and then naturally the confirmation that follows thereafter. Now, that is clearly only part of the requirements that need to be adhered to here, because we then naturally have our other aspects that we need to do. Like I said, the reporting that we spoke about a little bit earlier as well. So many of these sort of forms that can be produced via the Smarter SMSF site allow you to, I guess, view first the sample documents that we have, but work through the form to ensure that you've actually completed it as you need to. And where relevant, we may also then include some other instructions. So you can see in here, changes of directors. We have in here the ability to change, so appoint directors, remove, or appoint and remove. So if you've got that situation where you're adding more than one, again, in both elements here, you'll be able to do that relevant search from the navigation at the top of the form. So we're working on getting this changes of directors one added into the platform at the moment, to the new platform, but just noting that you can go to either to be able to complete that particular task that you can see there. So not only are we sort of capturing all of the relevant company and director information there, but then once we get to the removal and appointment page, it's then asking all of those relevant questions to work out the change that's obviously occurring and the templates that will get created off the back of it as well. So let's kind of keep moving through to help you to understand, I guess, some of the more complex ones that we see here. And this is really moving to the topics of things such as incapacity and the death of the member. So what we know from an incapacity event is that we are required to make changes at a director level, but ultimately the fund has the member continuing within it. And this is where we have to go back to our SIS definition, and we know the exclusions that sit within 17A from the all members must be trustees and all trustees must be members requirement that sits within that. Now, we can see here that when we look at the trustee issues in the event of incapacity, we need to not only understand the fact that if someone has lost capacity, we need the rules of the Constitution to allow us to consider the appointment of a replacement for them. So that is someone who has who is their legal personal representative. And this is why clearly special purpose companies are better than standard trading companies. So clearly you don't want to have clients in this situation having single trustees sitting over multiple entities where it is not a special purpose company, because one of the gaps that you will see is that in a standard company, it won't allow for that person who loses capacity to appoint an alternate for them. And that alternate would be someone that holds an enduring power of attorney for them, unless naturally that sort of stuff was specifically drafted into a constitution. So something off the shelf, you're not going to see that, whereas it's a common feature, or should be a common feature, under a special purpose constitution, because succession inside an SMSF and the operation and continued operation of the SMSF understands the fact that over time people may lose capacity and therefore need some type of legal representation to come into place. So when we look at this, we're not only looking at the obligations of the director, but we're also having to understand the requirements around share ownership, because share ownership also invokes decision-making that needs to happen in the fund. And this is where Rule 13.5 is relevant, where it looks at the fact that if legal representative is put into place, that they're entitled to the shares because of that incapacity of the shareholder to, again, make or allow them to make certain decisions around the continued operation of the fund. So if we come back to the requirements on the left-hand side here, we need to have that ability to appoint the enduring power of attorney as an alternate director in this instance. You could also, there's terms about successive directors and that sort of stuff. Ultimately, we're kind of coming back to the same thing here. Again, we need to ensure if someone's being appointed that they have their director ID in place at least 1 day prior to that appointment. If someone comes in under an enduring power of attorney, we also need to ensure that they have completed their requirements as a trustee or director of the corporate trustee. Again, if they don't have that done already. And then we have our various reporting requirements again around both ASIC and the ATO. Now, what I should note is that you can look at now, and if you joined us as part of our Smarter Legal Week, you can now look to produce enduring powers of attorney through our integration with Inherit Australia, which is done through Hill Legal. So you can go into here, this is under our new platform, and you can see the different powers of attorney that are in place here. So if you need a client that either requires an enduring power of attorney ordinarily or an SMSF power of attorney, which is kind of an EPA under the Smarter SMSF deed on steroids. I won't go into the specifics of that other than to say you can go to our Smarter Legal Week. So if you look at our legal area and go to Smarter Legal Week, we do have some sessions that we ran here, and you can go to the Creating SMSF Powers of Attorney, and both Chris and I went through this topic as part of our Smarter Legal Week, and you can clearly find out more about that, but get into the process of looking to complete that order, hook up the integration, and away you go in terms of arranging for that enduring power of attorney to be able to get completed for you. And in essence, you'd need to sign up the first time, but once you're through, it should single sign you on as you connect each and every time from there on in. So let's go back to our slides again and keep us on the journey in respect to changes around these incapacity events. So not only can you order the enduring power of attorney specifically through inherit, but where you have a situation whereby we need to look at removing that particular party, well, again, we now have in place specific documents on the Smarter SMSF platform that would allow for the appointment of that additional part or the alternate party, the replacement trustee ultimately for that person who can no longer hold that position as trustee or director of the corporate trustee. And this alternate director you can see here sort of fits within the guise of Rule 19. And what the alternate director definition within Rule 31 talks about is it's a person who is appointed as a director of the company on behalf of a member or the deceased member, according to the rules of the company, pursuant again to the superannuation laws, including that legal LPR of the deceased or LPR where they're under some sort of disability. Again, it may be because of age, so they're a guardian, maybe due to mental incapacity or for some other reason. And again, we do see circumstances whereby someone that is a trustee or a director of the corporate trustee, as they're getting older, do have a family member that they trust to take over the role of trustee. And therefore, they might not have lost capacity, but they simply don't feel adequate enough to be able to take on that role. So rather than someone coming in as a co-trustee with them, assuming that they're the sole member, what they end up doing is they resign from that. And as long as they have an enduring power of attorney in place, then that person can actually step into the shoes. So you could have, for example, Toby Citizen, let's say, and he's the sole director of the Citizen Family Fund. John's already passed away. Jane is the sole remaining member in the fund, but she doesn't really understand how this all works. As long as she can get her pension and keep drawing that out, she trusts her son implicitly. And therefore, yes, she could be a co-trustee or director with him, but equally, she could hand over the reins to Toby as long as he holds an enduring power of attorney. That certainly can take place as well. So again, inside the forms that we've built on the site, it allows you to look at those different decisions around the removal of a director. And what you can see at the bottom of the screen here is that we originally had this removal as a director around incapacity, but what we have done is we've now brought this back into it incorporating the appointments under an enduring power of attorney. Now, why is that the case? Well, it's quite simple, because what we have here is the fact that we have parties that go overseas, we have parties that lose capacity, so we have residency issues, we have incapacity issues, and as I just used in my example before, we may have issues where ultimately we have the fact that one party just doesn't want to continue to work in this guise. So if we just go Toby Citizen here, what we'll then see on the next screen is it starts giving us the choice of the way in which that person is to be removed. So is the person to be removed due to loss of capacity, or are they simply resigning as a director? So if they've lost capacity, naturally, they can't be a party to the document, and therefore it's the representative for them. If it's someone is resigning from the role, well, what is the reason? So we're then looking at either residency requirements or they just require support. So they've still got capacity. So again, in both of those instances, they would be able to sign that particular document. Where we're looking at the appointment under EPAs here, how many EPAs are there, how many of them are being appointed into the role, is the appointment then looking at the constitution, do those powers sit with the directors or do they sit with the shareholders, etc., etc. So again, the nuances of these changes are really important to get right, because if they ever get challenged, it will come down to the procedure around the decisions that are being made within the fund and then within the trustee structure that you've been working through with your client. So if we jump back again, apologies going backwards and forwards, but really important that we understand those clear and distinct processes and decisions around incapacity and ordinary appointments and I guess the use of EPOAs. And then we move to the changes of the trustee in the event of death. Okay, so we then here, very similarly to that incapacity one that we were talking about before, we have to consider things at the trustee level and then also at the member level. So from the trustee perspective, again, we have a time frame available to us for the appointment of the, go back a step. Let's go back a step. So the first thing that we actually have to do is we need to consider whether we are appointing someone else or not to step in to the shoes of that member, so their legal personal representative or executor, to deal with the payment of the death benefit. So that role will exist until such a time that the benefit commences to be paid to one or more beneficiaries. Now, what's crucial here is that that function is a permissive function within 17A, but not mandatory. So you really need to go back to your deed, because some trust deeds will mandate the appointment of the replacement trustee. The law, so 17A, 3A that you can see there, says that you may be able to do that. There is no mandated obligation to do so. So the Smarter SMSF deed follows what 17A requires, which is why if you go to our death benefit nomination form, or our binding nomination, we talk about in that document the concept of the replacement trustee. So in the event of death, does John Citizen want that person, whoever it is, to step into the shoes as the replacement trustee? Now, if he dies, Jane's the beneficiary, Jane's the one that's going to receive that, there may not be any need ultimately to bring someone else in to deal with the benefit. So therefore, Jane wearing multiple hats ultimately is the sole person in there dealing with the benefit that's going to go to her. There's no reason to have some other formal appointment. Very different in a blended family situation, whereby you may definitely want someone to step in, and you may even want some sort of guardian role to ensure that all that stuff is appropriately overseen as well. Now, before I sort of corrected myself before, as we spoke about that, the other important part to the trustee level is then we have our SIS definition that requires us to ensure that the fund continues to remain a complying fund within 6 months. Okay, so first and foremost, we want to ensure that the ability to pay the death benefit is done and is done correctly. And this could go down to the way in which singular and plural works within the definitions in the fund. So does it require trustee or trustees with individuals? So one person in the Smarter SMSF deed, if John and Jane Citizen in my example were individuals and John died, it would allow Jane to be the sole person there to pay out the benefit. In some instances, we see deeds that require someone to come in because it needs at least 2 people, because it talks about the definition within 17A, which requires that sort of 2 persons approach for individual trustees. Very different than to corporate trustees. But we have to get back to, even though the fund may allow for Jane to pay that out in her own capacity as the sole trustee in that period of time, we actually have to get back to that position within 6 months, or make a change from individual trustees to a corporate trustee as a result of John Citizen dying, so that Jane Citizen can remain as ultimately the sole member and director. So you can see on the rules on the right-hand side here within the Constitution in respect to the death of that director member. So again, at the request of the deceased member's LPR and subject to their consent, procedure, right? So consent becomes important. They may appoint, again, crucial, the deceased member's LPR as a director, provided that the fund retains its complying status. So again, we're not falling foul of any definition requirements within Section 17A. And then at the commencement of the payment, then there is a process of resignation in respect to that particular role. And around the shareholding, if the shareholder dies, the company will recognise only the LPR of the deceased as being entitled to those shares. And then we would go through the process of dealing with those particular shares via the estate of that particular individual. What we then need to do is, that's all at our trustee level, we then look at the member requirements. So this is really not part of today's session as such, but we're naturally looking at the form in which the death benefit is to be paid and who it's to be paid to, dependents and non-dependents, pensions and lump sum or any combination of. If it is a pension, is it to revert or is it non-reversionary? All those things naturally fall into the wheelhouse of those member level considerations. Now, the other thing that you can see here is with our individual trustees, that if you do have a situation whereby a person has died and we need to look at that change of trustee. So if I just take that back, so change of, and you'll see in here, we do not only have our change of trustee document ordinarily, but we do have our change of trustee in respect to the particular death of a member as well. So again, this is going through and looking very specifically at all of those requirements around the fact that the members died and those elements that we spoke about before in ensuring that we meet the definition. So we add a replacement trustee to comply within the 6 months, switching where relevant, the change of trustee here that you can see, the various minutes and so on and so forth. So again, a very different document around the change of trustee to what you would see ordinarily. So that's obviously with the individual trustees, contemplating who the member is, who the continuing trustee is, who the new trustee would be in this instance, where we are looking to continue in the operation of this fund, recognising that in this instance, Jill was the member who died, and then looking at the specific rules around the cessation of them as a trustee and member of the fund, and then naturally going through all of those various elements that are forming part of that particular change in there. Now, if a member dies in which they are a corporate trust, they're a director of the corporate trustee, then again, we're looking at a very different setup in respect to what the Constitution is saying, and therefore we are making decisions around the changes to the rules, changes to the shares, et cetera, as we spoke about a little bit earlier. So let's get ourselves back again over to, I guess, finish off some of these key areas in terms of the documents that we have. And I've really showed you today the broad spectrum of documents that we have in this area now. So as I highlighted with our changes of trustees, within an individual sense, you have that ability to do appointments, do removals, do appointment and removals. So individuals to companies, companies to individuals, and corporate to corporate stuff. We also have our change of trustee in respect to the death of a member. We are working on our deeds of retirement and appointment, where we have the appointment of the enduring power of attorney. So both in respect to incapacity and also residency. We have within our corporate trustees as well, we have our changes to directors. So the fact that you can add a director, which includes the alternate, you can remove a director, which will include the removal of the alternate director to reappoint that person if they maybe had come back from overseas, for example, and you can add and remove throughout that journey as well. We've got our removal of a director due to incapacity, we've actually that's been updated. Now I can actually say here, we've got our removal of a director, as we said before, both in respect to incapacity and residency. So through that enduring power of attorney process, the only one that we are actually working on now is just to wrap up that death of a member one there too. So the other, I guess, final thing that I just wanted to make sure you're aware of is that as you are working through these potential changes, you may be uncomfortable in terms of you just preparing some of that work, or you may just want that absolute peace of mind that that change is done and is done ultimately correctly. So when you are dealing with the change of trustee form, we have now introduced our Smarter legal review process into that form. So what you can see on the page here is part of our Smarter legal review process that we spoke about in our previous Smarter Legal Week events, okay, where we looked at this topic. Now, if you want to, you can simply ignore that and go through and produce that relevant document. But through our relationship with Hill Legal, you do and have the opportunity to obtain legal review in respect to that particular order. Now, subject to the number of changes that have occurred over time, it may be a simple scope review, it may be something that is more comprehensive. And then once you've uploaded that relevant information and you've provided any additional information, you can then review and submit that particular order for the change of trustee. Now, what is important as part of this approach is that it won't generate the order for you. It is going to simply create a saved order there in which that document will then go off to Hill Legal to go and undertake that particular legal review. And the one thing that you will see that is different from the site's point of view is that you end up with what you see as an amber here. So you can see here, this is for a deed of variation, but it recognizes that this document is currently at legal review. And only once the legal sign-off has been provided will you then come back in and then generate that completed order that you can see there. So that will allow you to see what document is at legal review and then complete it once you've got that particular legal sign-off. Now, inside of the forms here, and what I should say is at the top here, you can see that these specifically relate to the integrations. So as you're working through the completion of the form, you can go in and you can then go and select your relevant fund and then import that data from the relevant integration that you have with your SMSF software provider that you can see there as well. So you can go in and choose your relevant funds there. But once you get to the bottom, actually, I need to go back because I prepared one earlier for this. So we can see it over here. We've got our change of trustee. I'm just going to resume that out of the saved order. Save us a little bit of time having to rekey everything in. So what you can then see in here as part of this process, we've got on our second page here, and at the bottom of the screen, it asks us the simple question of, do you wish to request legal review of this order? So if you click no, you can simply go through. If you're clicking yes, you can then look to incorporate that legal review as part of the process. Okay, you would upload the relevant documents that will enable Hill Legal to go and review that information for you. You can have an opportunity to provide some more background information as part of that. And then equally, you would do some acknowledgements to say that you authorize Hill Legal to be engaged to undertake this review work. And you also acknowledge that Smarter SMSF is not providing legal advice here. That work is being conducted by a legal practitioner at Hill Legal. And as part of that process, in essence, those two things are being acknowledged. Now, what that ultimately all means for you is that when you go back to our completed orders page and we go in and we undertake that review, that information is then submitted to Hill Legal, and Hill Legal will go and undertake the review based upon your assessment and ultimately what you have paid for. So there will be a time frame for them to come back to ensure that that's been scoped right. If it has been scoped correctly, then they will pretty much get underway in respect to that work. They will be in direct contact with you, the professional that is getting that change of trustee or whatever document that may be. If the scoping is wrong because they've looked at it and they've found something that may need correction as part of that process, they will then go back to you and reconvene with you to re-scope that work. And then that payment would be made to them for the difference. And then Hill Legal and Smarter SMSF will sort that bit out that you may have already paid, noting that members would still be required. The document itself comes off your document counter, but the review itself would be payable still as part of the work that Hill Legal has to do. Once that work has been completed, as you can see here, you as the user would go back in, as I touched on before, and complete that and generate that particular order, because Hill Legal will send to you that legal letter sign off, so that comfort letter, so that you know that the document that has been prepared has now been legally reviewed and has been done validly. Okay, so the relevant changes that have been occurred and working through all of the elements that needed to be done to get that change of trustee done. So then, as I touched on before, once that letter of sign off has been done, you can then go back into the Smarter SMSF platform. As you can see here, you would change that legal review into clicking as I showed on the screen here before. So we would go into here and we would go, legal review has been completed. It requires you to acknowledge that that has been done, so that you're not simply bypassing it to generate that document. We then timestamp that on the order to say that you did that at that particular point in time. And then once we submit that, oops, need to click that and help, that will then change over ultimately to allow for that document to then be downloaded. Okay, so it will refresh the page and allow for us to then download that particular document for the client as well. So that's the process around the legal review. So you can see that that's changed there now and allows you to then access that particular order that had been done. So from a legal review point of view, our change of trustee is one of several that is available for that legal review to occur. Does also include update upgrades. We're doing some work around our binding noms right now, LRBAs, also fund guardians, and there are a number of things that we're sort of working on at the moment. But if you need that legal review, we can accommodate that already. And again, as I've touched on, we did run a Smarter Legal Week at the end of July, and there are 4 webinars on that page in which you can go back and not only understand things like our Smarter Legal Review service, things about the deed, the powers of attorney, and fund guardians. And then in addition to that, we also have our legal review page and what forms part of those different levels of review, including the ability to do certain rectifications where required in documents where they might not have been signed correctly, for example, or they are not dated properly and therefore require some of that stuff to be remedied along the way. So yeah, so a number of those things, and we're continuing to enhance that offer as more and more people start to utilize that as well. So that pretty much takes us to the end of today's session. So some key takeaways. I guess getting it right is crucial for your clients. And hopefully today I've identified for you some of those areas of risk, and in some areas I sounded probably like a broken record around procedure, but process is crucial. When events go to court, and we know it is happening more and more and more, before they even look at the facts, they will look at the documentation and ensure that the judge or judges know explicitly around the operative rules, the operative constitution, and therefore frame up themselves how they need to interpret decisions based upon what they understand is correct, not what others may assume is correct in that instance. So understanding how it can be done, the steps involved, and the order of what needs to happen is so crucial to getting it right. And that's why not only are we starting to build out the specifics of this and why we link all that stuff explicitly back to our deed, but giving you that smarter legal review oversight to assist you is, again, a key part to our service offering. We know that there are a greater number of clients requiring changes due to incapacity, death, and other events. So it's an area that's going to continue to grow, not only for us, but naturally for you. And we are therefore continuing our focus to build out a comprehensive suite of these things to be able to support you. And then we'll use the technology where relevant to be able to service what those changes look like and not only pull data down, but make updates back into your SMSF software to save time, to reduce error rates, all that sort of thing as well. So thank you for joining me today for that session. I hope you found it valuable, gave you not only some technical insight, but how it can be practically applied to some of the documents we have on our Smarter SMSF platform. If you do have any questions, please feel free to get in contact with us. We will be uploading this video onto our YouTube channel, so you can go back and have a look at this or share it with others to try and understand what we've gone through today. We do have a range of events coming up. Our next CPD session is our Changing Face of SMSF. We also have this month our courses update, where we're going to be going through a range of changes that we've been making into our Foundations and Essentials course. And then we have our we have our Smarter SMSF update around our document changes, features, and other things that we've been doing that our team have been actively working on, and around how you can manage your SMSF deeds as well. And finally there, both myself and Tim will be a key part of the SMSF Advisor Technical Strategy Days in Brisbane, Melbourne, and Sydney. So you can want to find out more and even have a chat to us. We'll be at each of those events too. So thank you once again. If you do have any questions, please feel free to get in contact with us. Have a chat now. Otherwise, thank you once again. Have a great rest of the day, and bye for now.